My name is Michael Komorn. I'm the founder of Komorn Law, PLLC here in Farmington Hills. Practicing law for about 25 years, mostly in criminal defense, but say over the last 10 to 12 years, primarily cannabis law, which includes criminal defense and compliance counseling and entity setups and business advice and things like that as we've gotten now into the licensing of marijuana businesses in Michigan. I got involved with Earl's case because his case was kind of a historic case in Michigan when it happened, and I'd kind of inserted myself into the middle of the developing medical marijuana laws and was taking on a lot of cases, and I just wanted to be involved. And I may have met him other places early on when the Michigan Medical Marijuana Act passed. There was gatherings and Compassion Club things, and I'd go speak at libraries, and he may even had me come speak at one of his clubs. So I kind of knew who he was, and I knew about his case going on. But the real tragedy of what had happened was when, after he lost at the trial level, the court made it an opinion. He appealed at the trial level and went to the Court of Appeals, and they wrote the Brownie case opinion, which he may have spoken to you about. But it was one of the worst opinions that I think has ever been written, and some really crazy, irrational use of the English language to try to describe the conclusion that they came to. But I and a couple other lawyers got involved at that point, appealing that decision from the Court of Appeals to the Supreme Court. Well, at the time that his case came out, it was we were learning what the bottom line was for the behavior associated with medical marijuana, and you wouldn't think it would go this way, but what happens is the ballot initiative was passed, 3.3 million people voted for the Michigan Medical Marijuana Act. A law gets written, it's approved by the legislature, and it gets enacted into law. You read the law, you think you know what it says. You think you know what to protect. You think you know who is immune from behavior that would otherwise be illegal, that being involved with marijuana. And despite all that, people are still getting arrested. So, Earl's case, emblematic because its impact for his own, the impact on himself and not being able to present or have immunity from the prosecution and having to defend himself, and also the impact that it had on everybody else in the state of Michigan. If you don't know, and he didn't explain it, I would say that Earl's case stands for the proposition that, and it was unknown at the time until the Court of Appeals ruled, but they ultimately said that the only marijuana that you can possess in Michigan under the Michigan Medical Marijuana Act was the dried plant material associated with the marijuana plant. That's it. And in Earl's circumstance, he was charged with possessing marijuana brownies. They call them marijuana brownies or whatever. They know they're marijuana brownies. But in this opinion that, and I'm paraphrasing a little bit, but they use the language of the highly potent but unmeasurable brownies. Highly potent, unmeasurable. You can't have those two things within the same. And that was the sentiment of this opinion, in that there's all this fear that we don't know what's in these things. There's so much THC, they're so high and dangerous, et cetera. Not true, number one. Number two, not a fact of or in evidence. If they can't measure the quantity of THC within it, they can't say it's highly potent. And his case comes out, which is just terrible. Like you have to smoke. Did the 3.3 million people really think that the law protected only smoking and kids could? But then you have the lab getting involved and just manipulating this from a bad opinion that said it's a marijuana brownie. He just doesn't get immunity. That's what the case. They turn it into, these are THC laced brownies, not from a marijuana plant. This is like the most bizarre step that the institutions of so-called justice took this. Okay, so Earl's case has that flavor to it as well, which in that I guess it was his case that inspired this gathering and conspiring to create false reporting of marijuana brownies. The brownie case, procedurally, is at a place right now in April of 2019 that you will not find another criminal defense lawyer that can tell you that they have a similar case that's like this. The procedural place that it's in is literally like an anomaly. It doesn't happen. It's not supposed to happen. So we had that hearing, but what the court didn't do is it didn't vacate his sentence. And all the while this is going, this case with the Court of Appeals, it came back, and we did the Section 8 hearing, he was still under sentence. In other words, the conviction still remained, even though they set it aside. So, he was convicted at trial, went to the Court of Appeals. Court of Appeals said, okay, we're affirming the Section 4 ruling, but we're vacating the sentence. His conviction should end, start over. We're remanding it back to trial. And he gets to assert his Section 8 there. And if he gets his Section 8, he can go to trial on a Section 8. You would not be going to trial on a case that you've already been convicted of. You wouldn't be doing all this if there was already a conviction. There's no need for it procedurally. So the court never set aside the conviction. And he has remained under sentence this entire time. So much so, to the extent that he has maxed out the possible sentence that could be given to him. He did some time in jail at the front end after the trial on the Brownie case. I was not his lawyer at the trial, as you know. But he also did more than 5 years of probation on the conviction that was sent to the Court of Appeals that was meant to be set aside or vacated and starting over again. But it's been 5 years and time in jail. There's Michigan, you can't be on probation for more than 5 years for a felony unless the statute allows for it otherwise. So he has maxed out. It can't hurt him anymore. I mean, theoretically, he could sit at the defense table during the trial and he could be sleeping and get convicted again, and they can't do anything to him. That's a rare situation. I don't think many lawyers are going to say we have been, like there's no harm that can happen at the trial. You asked the question of plea. There's no plea. People don't usually hire me to plea. People hire me to take on the broken criminal justice system because it's really broken, and walking in and doing a plea is not usually why they are hiring me. It's so big and so powerful, and they've become this way, I would suggest, by marijuana and the prohibitions related to marijuana. Statistically, in Michigan, if you went around any courtroom on any given day before legalization, you would find 40% of the docket were marijuana cases. We know that the Michigan State Police Forensic Science Division reported that 40% of its budget 2013, 14, 15, all the way up to legalization, was spent testing marijuana products. They would tell you that the reason that the rape kits, Michigan has this terrible backlog of rape kits not getting tested by the Forensic Science Division, they would tell you themselves that if you're spending 40% of your budget testing marijuana, do I need to say the next thing? The reason that the rape kits aren't gotten to is because we're spending 40% of our budget testing marijuana. This is the state of the affairs all the way up until legalization. Now, is there an explanation for that? Is there any logic or reason? Is there something to boast about that, 80%, that like the marijuana convictions are 80%, make up 80% in Michigan, or 20,000 people are arrested and convicted in Michigan every year for marijuana? But this is what it has been. How about this? That since 2008, 2009, since the MMA passed, forfeiture in Michigan hit a peak in 2012-13, $25 million a year. That's of what was reported. There's probably a lot more that wasn't reported. The Michigan State Police makes a lot of money every year in forfeiture. And when the MMA was passed, and these individuals who happen to own things because they're patients and caregivers and are not, they've lived, they've worked, they're associated, whatever they're doing, they've acquired things. When they find themselves in a technical violation under the MMA and you're not protected by the act, they are taking everything. This is not just things I'm saying. This is well documented over the last 10 years. And what these courts are doing and the number of people that are getting brought in, lodged into the system, given their ticket or their number that's going to follow them for wherever they go about marijuana. And you see the length that they go to with these individuals and just ripping their souls out of them as they go through this process with the court system. It was the medical marijuana that brought this to my attention, because I saw the way these individuals were just being sucked in and forfeited and overcharged and technical violation. No one cared. Like there's a difference of a culpability of mens rea, how people are thinking of intending to commit a crime, whether it's accidental or whether even the law is so clear and so well written that it's unequivocal and there should be no debate in terms of the interpretation. So I don't know, how many criminal cases does the Oakland County judges see per week? I mean, it's probably in that, probably 20 to 30, I'd say, 15 to 25, somewhere in that range, I would guess. This is the problem I see, that there's been this pattern of overcharging. They don't charge you with the crime where, okay, that's what our fight's going to be about. Fine. Let's go to trial. If I'm guilty, I'm going to plead to it. If I'm not guilty, I'm going to go to trial. Simple. Instead, you have, well, I might be guilty of this, but you got these other things here. Well, I'll tell you what. We'll dismiss those other things that, maybe you're really not part of. We just charge you because you got all this liability hanging over your head. You plead to the thing we really think you're guilty of. That's how you get 97% pleas. I mean, the experience, as everyone said, is the worst experience you could ever have in your life, and they do it so that you don't ever want to come back. Certainly way too much emphasis on, prosecuting for profit and, arresting for profit, and how the system becomes a method by which cities and townships and counties get revenue. That's a fact. That's been the most disturbing. One of the big issues over the years has been that someone they're allowed to grow 12 plants, let's say. 12 plants, closed out facility. Police officer comes in for something and sees it, it's fine. There's no debate about that. They cut one of the plants down. They lock up the other 11. That's total compliance. There's no issue. No one's going to say they've got more than their 12. What is this other thing? This other plant we just cut down. It's on a stalk. It's wet. It's got to dry. It's got all the leaves. We're not even at the bud yet, right? So year after year after year, when the police encounter this and someone's hanging plant drying, they throw it in a bag and they weigh it. Oh, it's way more than 2.5, right? So we have this case that comes out that is like, and anyone that would read the law would say, well, you're allowed to possess not more than 2.5 ounces of usable marijuana, which is defined by the dried. So if I have wet marijuana, it doesn't count towards my 2.5. But as I've learned, even though the law says that, in order to really understand the way the Court of Appeals, the prosecutors work, you have to think of the most sadistic possible interpretation that could be made, and that's what they're going to try. Remnants of the Carruthers case that defined unusable marijuana as not counting towards your 2.5 because it's illegal to possess, even though the amendments cured all that, that little nuance still remains. Therefore, if you're possessing any wet marijuana at all, it is illegal. Even though the amendments cured all that, that little nuance still remains. Therefore, if you're possessing any wet marijuana at all, it is illegal. So that means that anyone that's growing marijuana and they chop down their one tree, they're possessing something illegal. That's what this opinion says. You can't be a caregiver anymore, ultimately. That's what this opinion says. Every year, the state of Michigan is now required to produce a forfeiture report. The Michigan State Police do a forfeiture report reporting to the legislature, what their surplus was for forfeiture. This last year, 2018, was $15 million, down from $25 million in 2012. But anyways, the point is, this is a battle that goes on. They want words to have meaning. Read the statute as it applies. But instead we have judges creating concepts and words to actually thwart the intention of the law. To the extent that 50,000 people in the state of Michigan that are caregivers to harvest a plant are going to have a wet leaf, which becomes contraband. It's insane.